Hi, my name is Brandon Perron. I'm the National Director of the Criminal Defense Investigation Training Council, and I'm here to discuss a very important question that often comes up during the course of criminal defense investigation while working with an attorney as an agent of counsel, and that is to document or not to document. What does the criminal defense investigator do when a lawyer tells them, after a verbal report, to not generate a report, to not document the findings of their investigation? What does the criminal defense investigator do when a lawyer tells them in advance, when they accept a case, that they don't want reports, they don't want anything documented, they don't want anything in writing? Think about that for a second. And I want you to think about it within the context of being a professional investigator. Do you follow that advice? Do you follow that instruction? Do you do it without any questions or comments whatsoever? Or do you discuss it with the lawyer and ask exactly how you're supposed to do that and maintain the highest standards of professional conduct as a professional investigator? And how do you do it while at the same time preserving the record? Think about that for a moment. Think about it. I don't know what the answer is. I can say this: I would dare anyone to show me a specific policy, a specific rule, a standard in respect to best practices for either attorneys and or professional investigators, criminal defense investigators, public defender investigators. Show me a policy or standard in respect to best practices that states the investigator should not document findings in any way, shape, or form, whether it be in a report, work product report, in their notes, in some form. I dare you to find that to me and send it to me, because I've been unable to find it. And I don't know how an investigator can conduct a criminal defense investigation and not document their findings in any way, shape, or form, other than through a oral report that's provided to the attorney. And I would ask you, when they give you the instruction not to document any findings, not to put it in the written form, in the form of work product notes, or in any other format, are they giving you that instruction in writing, or are they also giving you that in an oral instruction with no record or document? Or do you have it in an email? Do you have it in a text message? Do you have it in an email where you can confirm it back and verify that this is what they're instructing you to do? And how does that tie up with your role as a public defender investigator in your agency? Is this an agency policy? Or is this something that that particular attorney is requesting? Is it that their practice? And how would that impact you if that case goes to trial, the defendant is found guilty, and then an ineffective counsel claim is filed against the attorney, and it could be based upon an ineffective investigation, and you are called to testify in that case, and all privileges are waived. Therefore, you have to communicate everything and all that you know relative to the case, and you have to disclose everything. And you are put on the stand, and on the cross-examination, you are asked where all your reports are. Where are your notes? Where are your findings, and how do you document those findings? And you state that I didn't do it. I failed to document my findings. And they ask you why. And your answer is because the attorney told me not to. Do you think the attorney is going to back you up in that? Are they going to support that statement? Or are you going to be held responsible? Is it possible that your failure to document and preserve the record could subject you to a potential lawsuit filed by the defendant? Think about these things. Professional standards are professional standards. Best practices are best practices. You need to reconcile best practices and ethical professional standards with all requests that are delivered to you through an attorney. Even though you are working as an agent of counsel, you have to ask the questions, the tough questions. That sometimes what you're being asked to do may be unethical, it may not be a best practice, and you may be held accountable for it one day. So is any one single case, is any one single lawyer, are they worth your professional career? Are they worth your integrity and your representation? I know the answer for myself. You ask the question for you and do the right thing. Thank you.